Good day, Crime Talk aficionados. I hope you had a great Labor Day weekend. First on the docket, the court takes care of some housekeeping matters in the Kohberger case. Oh, and the cops dump another 699 more photos. Suzanne Morphew goes to court today. We'll have a lot to talk about that. The defense of Donna Adelson. And a University of Kentucky student arrested after, they find a deceased newborn discovered in the closet. We have This Day in Legal History. Our legal quote of the day has to deal with justice, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications of when we go live or put up new content. And you can check us out on any of your favorite podcasting apps. Now, it is Tuesday, and so we are going to go live tonight, 6 p.m. Mountain Time. Please join us. We have a lot to talk about. Obviously, we can discuss Kohberger. We got the Morphew case coming up as well, which has a hearing this afternoon. We'll discuss here in a little bit. And since it will not be able to be rebroadcast, we'll be watching and we can discuss it tonight as well. All right. So before we get to the docket, let me remind you to go to CrimeTalkSearch.com where you can sign up for a background subscription service today. When you do, you'll be able to do a background search on anyone here in the United States. The search is literally prepared while you wait. It is emailed to you while you wait. And guess what? You can update it throughout the future when something else changes. You're going to get a report. You're going to find out phone numbers, email addresses, social media presence, whether somebody has a criminal history, are they married, are they divorced, are they on a sex offender registry? Yes, all those things that you want to know about somebody when they come into your life. So go to CrimeTalkSearch.com. You're going to be happy that you did. All right, ladies and gentlemen, let's go ahead and get to the docket for Tuesday, September 2nd, 2025. And as I said, the court took care of some housekeeping matters in the Bryan Kohberger case. As you may recall, back at sentencing, the court imposed restitution as well as the civil fines for each and every one of the defendants' families. So the court put up the stipulation regarding restitution, and it could be $1 billion. It's not like Bryan Kohberger is ever going to pay it. Anyway, the state of Idaho and the defendant, through their attorneys, stipulate to the entry of restitution as follows. Crime Victim Compensation Program, $14,393.13, which is money that just about every jurisdiction has, or all jurisdictions have, in regards to victim comps to help people out in situations. It could include counseling. It could include funeral expenses, whatever they need to help somebody out. But it's not unlimited funds. And guess what? Rarely does it get many money paid back into it because, people that usually commit serious crimes that involve serious crimes don't have the means to pay any restitution because they're going to prison. Jim and Stacy Chapin, $5,720.72. Jeffrey Kirk Kernodle, $8,843.03 for a grand total of $28,956.88, which has already been paid, but will obviously not be reimbursed. Then we have the civil judgment fine that was entered in the amount of $2,500, which must be payable through the clerk. And guess what? There's going to be interest at 9.125% per annum from the date hereof until paid in full, until such further costs and disbursements are made. So that, as it relates to... that was the order in favor of Ben Mogan. We have a civil judgment here as it relates to Kara Kernodle, $2,500 at 9.125% interest. This one here is for Jim Chapin in the amount of $5,000, once again at 9% interest. Stephen Gonsalves and or Christy Gonsalves, $5,000, 9.125% interest. Karen Laramie in the amount of $2,500 with the 9% interest. Then we also have Jeffrey Kernodle, $2,500 plus 9% interest. And then the order of restitution, as I noted, that is in favor of the victim comps. Also, Bryan Kohberger will owe 9.125% interest per annum on the all the money that has been paid and will be paid, which everybody knows will not be paid, hence the reason for the stipulation. Everybody knows he's never going to pay it. But it's finally, in written form, so it's officially part of the court record. Oftentimes, yes, the court does it orally on the record, but if it's not on paper, it really didn't happen. You got to make sure it's always on paper. Next, as it relates to Bryan Kohberger, is that the Idaho State Police have now disclosed another 699 evidence photographs, including the images of Bryan Kohberger's one-bedroom apartment there at the Washington State University in Pullman, Washington. Now, the apartment appears pretty minimally furnished with empty shelves, bare cupboards, and a nearly vacant closet containing only coat hangers. Now, the walls lack any pictures, posters, or photographs or family members or friends, and personal items are quite limited, consisting primarily of criminology textbooks and 2 birthday cards received approximately 2 weeks following the murders of the 4 University of Idaho students. So, as most people know, back on November 13th of 2022, Kohberger entered a residence at 1122 King Road and fatally stabbed the 4 college students. No motive has been established and no prior connection between Kohberger and the victims has been identified. And Kohberger turned 28 on November 21st, 2022. One birthday card featuring a floral design containing a message about a son leaving home while remaining in his parents' hearts, and it appears to be from his parents, Marianne and Michael Kohberger. The second card displays a cartoon of President Theodore Roosevelt riding a dinosaur with handwritten annotations including both of your egos and you are a dino plus a professor, along with a smiley face and the address Bryan. Portions of the card include internal messages that have been redacted. Now, accompanying envelopes include one decorated with small hearts and inscribed "Happy Birthday, Bryan." The sender of the second card remains unidentified. So, and as we've talked about before, analysis of Kohberger's cell phone records by forensic experts from the Celebrite company retained by the prosecution indicate frequent communications with his parents, but no real interactions with friends or peers. Now, the photographs reveal several books from Kohberger's criminal justice PhD program titled Mass Incarceration on Trial, Trial by Jury, and Why the Innocent Plead Guilty and the Guilty Go Free. Pages from his essay and assignments include professor feedback and grades. They're also visible. Another document features repeated writings of his name and dates across full sheets of paper. Cupboards contain trash bags and cleaning supplies with a few articles of clothing remaining in the closet, and the bathroom shows a clean bathtub without a shower curtain. A selfie taken by Kohberger approximately 6 hours after the murders depicts him with wet hair, wearing a white shirt and gesturing thumbs up in front of that shower area where a white curtain edge was previously visible. At the time of the arrest, no shower curtain was present. Now, the bedroom includes a neatly made bed with a dark bedding and a desktop computer on the desk. And in the kitchen, the refrigerator holds items consistent with a vegan diet, such as vegan cheese and tofu packages. Other items include multiple parking tickets and election pamphlets. Now, during the search, investigators photographed and collected a black glove from a closet, receipts from Walmart, Marshalls, and Dickies, and a small red stain on a white pillow. No evidence directly linked to the murders was recovered from the apartment, which the prosecutors described as sparsely furnished with no items of evidentiary value. Now, you have to remember the police didn't get there until several weeks after the murders. So really, what would there be? Because, he was moving across country with his dad. Now, Kohberger departed the apartment back in mid-December of 2022, driving the approximate 2,500 miles to his family's home in Aubrittsville, Pennsylvania, accompanied by his father. Now, prior to leaving, he faced multiple complaints from fellow students regarding his behavior, leading to placement on an improvement plan where he was subsequently terminated as a teaching assistant and lost his PhD funding upon arrival in Pennsylvania. Now, a document outlining the improvement plan was among the papers left in the apartment. Additional photographs depict Kohberger's office at the university, where a whiteboard displays the message, "Take it easy and don't give up." Now, Kohberger was linked to the crimes, obviously, through DNA on a K-bar knife sheath found at the scene near one of the victim's bodies, and he was arrested on December 30th of 2022 at his parents' home in Pennsylvania. Testing the charges for over 2 years, Kohberger entered a guilty plea in late June of this year as part of a plea agreement to avoid the death penalty, waiving his right to an appeal. And then on July 23rd of 2025, he received a sentence of life imprisonment without parole at the Ada County Courthouse in Boise, Idaho. And he is currently serving his sentence, his 4 consecutive life sentences plus 10 years at the Idaho Maximum Security Prison in Kuna, Idaho, and has submitted multiple complaints regarding other inmates being mean to him. So what can you say, ladies and gentlemen? It keeps trickling out. Really, I think we've seen the bulk of what they have on Bryan Kohberger, at least we've heard about it. Obviously, the judge late last week blocked the release of the crime scene photos. I get both sides of the argument. I frankly think it should be released, not because I'm into weird, gory stuff, but I think the public has a right to know, to be able to see the brutality of what one person did. If we go around ignoring things and it's not serious and it's not brutal, and it's not violent, well, I think people think, well, it's not that bad. It must have been okay. So not that I'm saying you have to be forced to look at it, but if you want to be able to see it, to see the brutality of what another human being can do to another human being, I think it needs to be out there. I also understand the family doesn't want that out there as well. But throughout history, and when there's been photographs, crime scenes have been made available. The photographs have been made available. They're redacted. You can still do it in a decent way so as to not be too graphic. Now, remember, just like in a trial, usually the prosecution wants to submit all the photographs. The court says, we're going to give you some of them because at a certain point, it just becomes so prejudicial that it's just not fair, so to speak. And that makes sense at a trial. You want to have a fair trial. Well, but the trial, there is no trial. It's over. Remember? He pled guilty. So we should be able to see what took place. I understand both sides of the arguments. I really do. I just think we need to lean more to openness when it comes to these types of records now that the case is over and the investigation is over as well. So let's move on. Next, let's talk about Bryan Morphew and his anticipated motions hearing this afternoon for a bond reduction argument. So, Bryan Morphew is scheduled to appear in court on Tuesday afternoon, where his counsel have submitted a request to decrease his $3 million cash-only bond. Now, Morphew is facing charges of first-degree murder in relation to the death of his wife, Suzanne Morphew, following a grand jury indictment earlier this summer, and the indictment alleges that Morphew was the sole private individual in the vicinity at the time of her disappearance who had access to a specific tranquilizer detected during her autopsy. Now, Suzanne Morphew's death was officially classified as a homicide after an autopsy revealed the presence of a potent combination of sedatives, collectively known as BAM, in her system. She was reported missing by a neighbor on Mother's Day back in 2020, and her remains were discovered in a shallow grave in Saguache County back in September of 2023. Now, remember that, ladies and gentlemen, it's pronounced Saguache, even though I've lived here in the state of Colorado, and apparently there's 2 ways of pronouncing it, but apparently the official way, we're going to go with Saguache, but it's spelled Saguache, and apparently, obviously, like most of the counties here in the state of Colorado, are named after Indian tribes. Anyway, this marks the second occasion for which Bryan Morphew has been charged with his wife's murder. He was initially arrested approximately 1 year after her disappearance, facing accusations of first-degree murder after deliberation, tampering in physical evidence, and attempting to influence a public servant. And then in April of 2022, a judge approved the prosecution's motion to dismiss the case shortly before the trial was due to commence there in Fremont County. The dismissal was without prejudice, allowing for the potential refiling of charges. Now, Morphew was apprehended in Arizona on June 20th of this year and is now slated for trial in Alamosa after the grand jury found sufficient probable cause. Well, he's not actually set for trial just yet. Anyway, his current bond is set at $3 million payable in cash only. Towards the end of August, his defense attorneys filed a motion proposing a bond reduction to a maximum bond of $500,000, which could be satisfied through cash, surety, or property. Now, in the motion, the defense describes Morphew as an honest individual who is sincerely motivated to vindicate himself and restore his previously positive good standing. Additionally, at the close of August, Suzanne Morphew's brother, David Mormon, submitted a victim impact statement to the court, and Mormon opens by reflecting that he has spent numerous sleepless nights contemplating the final moments of his sister Suzanne's life. He urges the court to deny any interim release of Mr. Morphew, stating, "I am confident that the grand jurors who decided the indictment would concur." Now, Mormon further labels Morphew as a flight risk, a characterization contested by the defense in their submission, and in advocating for a life sentence without parole, Mormon portrays Morphew as a remorseless, cruel, unethical individual who has exploited or preyed upon those in this circle through his life. So the status conference is set for 1:30 today. Probably won't have this video up. I anticipate motion for bond reduction will be denied. Now, a couple of things. We won't be able to bring it to you because you can't record it. You can't rebroadcast it here in Colorado unless the court grants permission, which the court has not. And so what does that mean? We're going to get little snippets here and there. But the reality of it is that I don't want to go to jail for being held in contempt. We'll bring it to you live and we'll talk about it tonight at 6. Now, one of the things I think is worth noting, we've done this before, is let's just get the facts. We know that Barry Morphew has filed a motion for a bond reduction. Normally, the prosecution doesn't file a bond reduction response. They just show up, they argue it, and they usually get what they want. In this particular case, the prosecution filed a very relatively short but concise order. So let's just or concise motion in this particular case. So the 12th Judicial District grand jury returned an indictment charging the defendant with murder in the first degree on June 18th for killing his wife, Suzanne Morphew. The defendant was charged with the same crime in 2021 prior to the discovery of Miss Morphew's remains in 2023. The case was dismissed without prejudice in a different judicial district. As the indictment makes clear, the evidence against the defendant is more robust than the evidence presented in 2021. Significantly, Miss Morphew's remains were found after the 2021 case was dismissed. The people will present evidence that the remains of Miss Morphew contained a chemical compound that the defendant had practically exclusive access to at the time of Miss Morphew's disappearance. During the course of their investigation, police acquired information about the travel plans and financial patterns that raised concerns about the defendant's ability to absent himself from the jurisdiction to avoid prosecution. For example, through the use of license plate reader technology, law enforcement learned that the defendant has traveled in 2 different vehicles with the same license plate, Indiana F397FR, through several states from 2023 to 2025. He traveled to Indiana, Missouri, New Mexico, Arizona, Utah, Florida, and Wyoming. The defendant has the means to travel internationally. Law enforcement learned that the defendant traveled to Mexico after the 2021 case was dismissed. Law enforcement further learned that the defendant has significant means to finance an absconding plan. He purchased a condo out of state for his daughter and transferred the deed to his daughter's name. And while jailed, he has communicated about the value of the stock he sold and the substantial rental income he is collecting on his Arizona property. Law enforcement has obtained communications about the defendant's transferring money between accounts with his daughter and providing for this daughter's living expenses. The defendant has used and continues to use an alias. He refers to himself as Lee while he has been in custody and appears to continue to conduct business in Arizona using this alias. Legal argument. Sierra 164103 identifies the relevant factors the court may consider in determining the method and conditions of a defendant's release on bond. After considering all of these statutory factors, a trial court's determination of bond is reviewed for only an abuse of discretion standard. That's for appellate purposes. The defendant correctly listed the statutory factors in his motion. The defendant argues that the $500,000 bond he posted in the 2021 case was sufficient to ensure his appearance in court. The This case, however, is very different. If convicted at trial on arguably much stronger evidence, the charge against the defendant requires a mandatory life sentence. The defendant's circumstances are different than they were in 2021. There is evidence that the defendant has substantial means, increasing the defendant's flight risk. Moreover, the defendant has demonstrated a willingness to take action that conceal his identity, like using an alias and interchanging vehicles with the same license plate, increasing the defendant's flight risk. The bond set by the defendant is not unreasonable in comparison with other murder cases in the 12th Judicial District. The defendant was significantly less ability to abscond. The Henry Corral case was recently convicted of murder in the first degree, and they cite the case number in Alamosa. The court set Mr. Corral's pretrial bond at $5 million cash only. Similarly, Larry Chavez, a defendant accused of murder in the first degree, must post $5 million cash or surety to be released on bail. Many of the facts the defendant relies upon his motion have already been considered by the court in setting the original bond. In setting bond in this case, the court acknowledged the defendant's compliance with bond in the 2021 case. The court also considered the defendant's limited criminal history. Finally, the court evaluated his bond decision in light of the amount of the conditions of the defendant's previous bond in 2021, noting that the alleged facts of the present case are distinct. There are no new material facts raised in defendant's motion that warrant a reduction in bond. Because you have to remember, ladies and gentlemen, every defendant, every time they want to go to court, wants to argue bond if they're in custody. You don't get it. You get one bite at the apple, and you have to show some sort of changed circumstance, not just the passage of time that would warrant a bond reduction. Now, the court said it when they issued the warrant. This is his chance to argue bond. I'm guessing the motion is going to be denied. Why is that, ladies and gentlemen? Well, it used to be in the state of Colorado, when we had the death penalty, murder was considered a capital offense, according to the Colorado Constitution. And then in the statute, it said that you could be held without a bond for a capital offense. Well, guess what? Since the governor and the legislature signed a bill removing the death penalty, guess what? Murder in the state of Colorado is no longer a capital offense. Therefore, everybody is entitled to a bond. But normally the bond will be so high that you cannot make the bond like $3, $5, $7, $10 million cash only. Sometimes it'll be as low as, I think, $1 million. I think I got a client on $1 million bond right now, but it might as well be $10 million because the odds of that particular client making that bond are about 0 to none. Zilch, zip, nada, nothing. So we'll see. We'll talk about it tonight at 6 o'clock. Oh, and the other thing I want to talk about, motion for civilian close. Okay, blame Bryan Kohberger for this. His attorneys have filed a motion for the defendant, Barry Morphew, to wear clothes, civilian clothes in court and not to be shackled. Now, the court issued an order saying, fine, he can, as long as the clothes get there in sufficient time, he can be dressed out, and he can not wear handcuffs and shackles. But guess what? He's going to have a stun gun or whatever other items they have, usually a leg brace, so that he can't run away or do anything along those lines. But this all comes back to the Bryan Kohberger case. Normally, when a defendant is in pretrial custody, you don't get to dress out because there's nobody there to see the case. The jury, the people that are going to see the case, it doesn't matter. And everybody knows it's a murder case. You're going to be in custody, regardless of what the bond is, okay? So the people at the jail hate it because they got to keep track of the closing. They got to get the guy dressed. He somehow thinks he's special to go to court when, 99.9% of the other defendants that go to court in custody are not going to be dressed out. If I were to make that request in a larger jurisdiction here in the metro area, I would literally be laughed out of the courtroom for doing that, unless it was a significant, perhaps sentencing date, something along those lines. Maybe you could do it. But for the most part, judges are going to say, I don't care if the guy's in civilian attire. It's not going to make any difference to me, whether it's jail garb or civilian attire. So let's move on. We'll talk about it tonight when we go live at 6 p.m. Mountain Time. Join us. Next, the Donna Adelson case. That's right, Donna Adelson, the 75-year-old Grandmother accused of orchestrating the murder of Dan Markle, a Florida State University law professor, amid a contentious custody dispute between Markle and Adelson's daughter, Wendy Adelson, following their 2013 divorce. Now, the prosecution alleges that Donna, motivated by her desire to have her grandchildren closer to her in South Florida, conspired with her son, Charlie Adelson, and others to arrange for the killing. The trial is being held in Tallahassee, Florida, and it's drawn obviously a lot of attention due to the high-profile nature, and they just keep plucking family members off one by one. Anyway, a lot of family dynamics and extensive evidence, including wiretap calls and jailhouse informant testimony. And the prosecution rested its case last Friday on the 29th after 6 days of testimony, with the defense set to begin presenting its case today. We'll talk about it more tonight. Now, last week's testimony painted Donna Adelson as a manipulative figure central to the murder-for-hire plot, supported by wiretaps, phone records, and confessions. The prosecution's case focused on her motive tied to the custody dispute, financial involvement, and the attempts to flee, and also, the request to suborn perjury. The defense has sought to undermine this witness credibility issues and distance Donna from direct involvement. The trial continues to unfold, and we're bringing it to you live. Next on the docket, kind of a sad story. A University of Kentucky student arrested after, they found a deceased newborn in her closet. So a 21-year-old University of Kentucky student and member of the competitive cheerleading team has been arrested following the discovery of her deceased newborn infant at a residence near the campus in Lexington, Kentucky. Laken Snelling was taken into custody on Sunday after police responded to reports of an unresponsive infant. Upon arrival, officers located the newborn wrapped in a towel and placed inside a black trash bag in a closet. Snelling, identified as the infant's mother, admitted to giving birth during an interview with investigators. The newborn was pronounced dead at the scene. As of right now, she faces charges of abuse of a corpse, tampering with physical evidence, and concealing the birth of an infant. Snelling is currently being detained at the Fayette County Detention Center. Now, the cause of the infant's death is under investigation by the coroner's office. Now, Snelling is a senior at the University of Kentucky and has been a member of the stunt cheerleading team for the past 3 seasons. Now, university spokesman confirmed her team affiliation and directed further inquiries to the police department. So nearly all abortions have been prohibited in Kentucky since 2022, and Snelling was previously recognized as the Jefferson County's fairest of the fair. Just goes to show you how quickly life can change. Next on the docket, this day in legal history, September 2nd, 1789. The United States Department of the Treasury is established by an act of Congress, creating a key federal agency responsible for the financial and monetary matters of the United States. On September 2nd, 1945, Japan formally surrendered aboard the USS Missouri, ending World War II and leading to the Treaty of San Francisco, which was the post-war legal framework for the surrender. On this date in 1963, the Alabama governor, George Wallace, forcefully halts public school integration, prompting federal legal intervention in civil rights enforcements. That's right. The then Alabama governor, George Wallace, surrounded the Tuskegee High School with the Alabama National Guard troops in an effort to prevent its integration pursuant to a federal court order. And then President John F. Kennedy federalized the guards and ordered them back to their barracks, which they did. So I guess that's right. The president does have control over the National Guard. Remember that, ladies and gentlemen. It's a thing. Next, how about a legal quote on justice? Justice is the constant and perpetual will to allot to every man his due. All right. The quote encapsulates the principles that justice involves consistently ensuring each individual receives what is rightfully owed to them, reflecting fairness and moral equity in the practice of dishing out the law. And then finally, our dumb criminal of the day. A grandfather's weird scoop scandal. That's right. A Dairy Queen debacle with a druggy twist. So a North Carolina grandfather allegedly turned family treat time into a pharmacological fiasco that has the audacity to pay the concerned whistleblower. So James Yokley Jr., a spry 66-year-old beacon of electoral integrity, finds himself in a sticky situation after purportedly spiking his granddaughter's frozen delights with cocaine and MDMA, aka ecstasy. So police in Wilmington have slapped him with some serious charges, including felony child mistreatment, narcotics possession, and tampering with edibles in a most unseemly fashion. So here we go. On August 8th, Yokley saunters up to a patrol officer at a fuel stop, feigning outrage over mysterious tablets discovered in the girl's Dairy Queen confections. One can only imagine the officer's raised eyebrows. Fortunately, healthcare experts examined the young ones and confirmed no ingestion had occurred. The pills, later identified as a cocktail of ecstasy and cocaine, remained mercifully uneaten. But oh, the irony. That's right. Security cameras allegedly captured Mr. Yokley himself orchestrating the illicit addition, turning what could have been a sweet memory into Exhibit A. As the presiding figure of the Surrey County Elections Board, Yokley was briefly detained before securing his freedom with a hefty $100,000 bond. Court orders now keep him at a safe distance from the affected grandchild, ensuring no encore performances in the frosty family drama. The community, meanwhile, ponders the enigma. What possesses a pillar of democracy to concoct such a hazardous sundae? So, yes, that's right, sir. Yes, you are our dumb criminal of the day. Was he trying to be a hero? What is going on? Unbelievable. But what can you do, ladies and gentlemen, other than read it? Mr. James Yokley, you are a dumb criminal of the day. Now, sure, we'll give you the presumption of innocence, but that videotape can speak a million words, can it, sir? I mean, what? That's just weird. I don't know if he's trying to be a hero. Was he trying to do something inappropriate with a granddaughter? Who knows? But Mr. Yokley, not smart, dumb. All right, ladies and gentlemen, that's all we have for you today. Thanks for joining us. Remember, please join us 6 p.m. Mountain Time when we go live. We'll take your comments, and we'll probably put the call-in line as well. We'll talk about Morphew, we'll talk about Kohberger, and anything else you want to talk about. So remember, the Constitution matters.